Good afternoon, everyone. Welcome to our weekly COVID webinar. I am Jackie Godapur-Werns, and I'm excited to welcome you today to talk about our Biden proposals and an update on COVID issues. What do we know now? With me are the Frantic COVID team members you've come to know and trust. We have Dana Fattore Crumley, Jennifer Smith.
Hello.
And also this week, we're pleased that our partner Bill Pokorny is joining us to discuss the Biden proposals impacting educators.
Thanks, Jackie. Good afternoon.
So before we begin, some light housekeeping. Please submit your questions through the Q&A function on Zoom. It is much easier for us to keep track and answer your questions there than in the chat, where sometimes they can get lost. Also, please mark your calendar for next week's webinar, which is IEP season in the time of COVID. And please make sure to watch your email for registration details. You will need to register for each week separately. As always, please submit your questions using the Q&A today, but also remember that you can submit questions through email before our sessions. And you can do that by sending an email to covid@frantic.com. And we really do appreciate those of you who sent questions in today. If you have any follow-up questions or would like to discuss any of these issues further, of course, you can always contact any one of us or any other Frantic attorney. All right, let's jump in. So the centerpiece of the Biden agenda is a $1.9 trillion COVID-19 relief bill. As major employers, the proposal would have several impacts on school districts. So Bill, can you start out by explaining the proposal on FFCRA, sick and child care leave? Many administrators are concerned about changes that are occurring just as they are making leave determinations for return to school.
Absolutely, Jackie. And so let me preface this by saying that we have not actually seen the text of any legislation yet. So a lot of these details, even as to what the proposals are going to be, are still up in the air. And of course, any legislation has to actually make it through Congress. There's a very slim majority in the Senate, as well as the House for that matter. And I think the president has made clear that his preference is to have a bipartisan bill that's subject to negotiation. So whatever is in the proposal, details are certainly subject to change as we go through. But what has been proposed, at least has been reported so far, is a return to the FFCRA leave provisions that we saw put in place back in the spring, early on in the pandemic. So just very quick review for everybody. What those provisions required were 2 weeks of emergency paid sick leave for various COVID-19 related reasons, and up to 12 weeks of leave at 2/3 pay for employees who need leave to care for a child whose school is closed for COVID-19 related reasons. Those leave provisions were limited to public sector employers, so including public school districts, as well as private sector employers with fewer than 500 employees. And there was also an exception for small employers under 50 employees. Private sector employers got a tax credit to pay for all that paid leave. The public sector school districts did not get that tax credit. Those leave mandates expired as of December 31st. So we've talked with a number of you as to what do we do now that that leave has expired? Do we continue providing leave in some form? Is it going to be paid or not? As part of the last relief package passed just at the end of this last year, the tax credits that were available only for private sector employers were extended for employers that continue to voluntarily provide that leave. But those tax credits remain unavailable to public sector employers. This new legislation, if it is enacted, would essentially reinstate the FFCRA leave mandate. It would expand the maximum amount of leave available to 14 weeks. Now, we don't know if that's 14 weeks for the sick leave provisions and the family leave, or it's just for the family leave. Again, these details haven't been published yet. The leave mandate would likely extend at least through this fall, again, subject to change in the legislative process. and the requirement would be expanded to all employers. So it already applied to all public sector. It would now apply to the entire private sector as well. So no maximum employee count. Employers under 500 would still get that tax credit, but as far as we know, that tax credit would not be available to public employers or school districts.
Thank you, Bill. So do we expect that this would start as a brand new program? So we had a couple of questions during the registration process about can people who've already taken FMLA or FFCRA leave in 2020 take the new leave? What are we expecting? I know we're reading the tea leaves a little bit, but have you heard anything about whether this would be a brand new program or piggyback on what's previously been there?
Yeah, so my short answer is I do not know. My expectation would be that if it's going to get through Congress, it's likely going to have to be a continuation of the prior leave allowance. So it may be tied to your FMLA leave year. So an employee who used it early on, but then gets sick over the summer, as you would with FMLA, it may roll over if you're using that rolling leave year, or if you've gone into a new school year, if hopefully we're all back in school and more or less back to normal by the fall, but who knows? If it extends into that long, you may have if you used a fixed leave year, rollover. So if it's tied to FMLA, that's my guess as to how it'll be handled, and it will be treated as a continuation of the old program. But that's just a guess on my part. I don't have any inside knowledge on this one.
Right, and thinking about this like from a practical perspective, you had a lot of school districts for the fall period that didn't, even though the FFCRA leave was there, people did not avail themselves of it practically because many school districts said, we're running a remote program. We're still negotiating with the union. Teachers may come into the building to teach, but are not being compelled to come into the building to teach. And so as long as they had those work from home allowances, people, even if they did have children at home to care for, weren't using this part of the leave. So I think whether or not it's an extension or they say when you've used it or not, is not going to have as much practical effect in many school districts because of the fact that they have had these periods of closure where the leave wasn't necessary in the fall. And this is creating so many practical issues, Bill, because we're making these determinations. We didn't even talk about like work from home determinations, and we're making these determinations sort of in the moment. And we're giving advice as to what was effective till December 31st, what was passed at the end of the year that really didn't continue those provisions to a large extent. And we may have to switch again. And there's just not a lot we can do about that. We have to just take this wait and see approach and think long term about what our needs are. I think that there's always the legal requirements, and obviously we need to stick to those. But if you can run your program, if you don't have students registered to come back and you can grant accommodations, that might be a better approach than, engaging in all the work that it takes to really deny or engage in the process. So there's always practical considerations that I think it's important to think about.
So Bill, there's also in this new legislation proposal of a $15 per hour minimum wage. Can you talk to us about how that might impact public schools?
Sure. Well, so the first question is that $15 minimum wage proposal ever going to make its way through Congress? I think that's a very open question. It certainly has been a centerpiece of President Biden's campaign in pushing for that minimum wage increase. And so I do, the fact that it's included as part of this relief package certainly says something about where it ranks in the administration's list of priorities. But there's obviously going to be very strong pushback from the other side of the aisle. And it remains to be seen how that's going to be implemented. Is it going to be an immediate increase, which I think would be even harder to get through, or is it going to be a phased increase over a period of time? Again, this falls into the category of we don't exactly know whether this legislation is going to pass or how quickly an increase would come into play. The obvious impact, if it does come into play, if it is passed on school districts, is if you have anybody who's earning less than $15 an hour, you would have to increase them to the minimum wage. And I think there's also a high likelihood that if the minimum wage is increased to $15 an hour, at the low end of your compensation schedule for workers who are hourly workers, you are going to see some compression and some pressure to increase wages for even workers who earn above the minimum.
So the relief legislation also includes some proposals related to OSHA. Bill, can you talk to us about those?
Yeah, I think that's in the short term going to be the much more significant piece of this for schools. So, as you probably know, ordinarily the Federal Occupational Safety and Health Administration doesn't regulate local governments, school districts. So, we're looking for school districts primarily at the state regulations, what we're getting from the Department of Health and the Board of Education. But we're looking to federal OSHA to set the standards. So there's a couple things going on. Number one, as of today, actually, President Biden is signing an executive order that's directing OSHA, the federal OSHA, to develop a stronger COVID-19 safety guidance and possibly an emergency standard that private sector employers will have to comply with. Now, again, that may not apply directly to school districts, but you can imagine that if the federal government is issuing guidance that applies broadly across all public sector employers, school districts are going to need to pay attention to that, for their own employees' safety. And you can bet that state regulators are going to pay attention to those guidelines as well. But the bigger push as part of this COVID-19 relief legislation is actually to expand federal OSHA's authority and give it regulatory authority over frontline state and local government workers, which presumably would include school personnel who are working in person in schools and who have a risk of exposure. So if that does come to pass, school districts are going to have to comply with those federal OSHA standards, whether the state decides to adopt them or not.
This is another issue that's going to have great practical implications because many of our clients are right now in negotiations or in litigation or dispute with their labor unions regarding health and safety issues and what actually is required for teachers to come back to school. We have school districts that are making huge investments in infrastructure in terms of HVAC systems, different cleaning protocols, all sorts of things that really they're not obligated. Some of them they're just at this point not obligated to do. But if that were to shift, again, that's going to be a major change in practice and impact all of the current disputes on this issue moving forward.
In addition to the OSHA guidance, we're seeing stated intent to come out with just robust return to school guidance. And to your point, Dana, I mean, this ship has sailed for most school districts. So if it conflicts with what you've done, I mean, you could see two scenarios. You could see, or more than that probably, but one is the guidance, you're complying with all the guidance, you've done more than needed. So maybe you spent more money, or they say, there's some lessons learned and some things weren't protective that we thought. I don't know if they'll be science-based, but studies will say, oh, you didn't have to have this much distance. I don't know what they'll come up with, but you could see that we've done too much. You could also see we haven't, they come out and they say you have to do a bunch of things that our school districts have not done, in which case they're already open. I mean, every day then presents kind of some risks and issues. So I just saw those headlines today, and it made me quite nervous as far as how they're going to accomplish that.
Yeah, I mean, I had a request, a leave request come in, or it actually was a work from home request come in this morning that the person said they cannot come in even after there's a vaccine unless they have a HEPA air filter. And it was a laundry list of items. And I am concerned that, I mean, first of all, just practically, you can't mitigate every single risk that's involved with being with other people. I mean, even if, you know, there's just no way to do that. And I'm afraid of just the, you know, obviously we all want reasonable regulations. We want workers to be safe. We don't want to go back to why they started the labor movement. We don't want all that stuff. But at the same time, it is alarming of like, where is it going to end? And is it a good use of resources? You know, given all the other problems we face in public education, you know, is it a good use of resources to make a school gym as sterile as an OR? You know, after this passes, you know, who knows what the answer to that is, but it does concern me as well.
I think on the positive side for schools and for educators, you know, the Biden administration has made it pretty clear that getting kids back in school and having schools open is a high priority. And so, and even in this relief legislation, even as they're saying that they want to adopt OSHA standards that'll apply to frontline public sector workers, they're also saying, and we're going to give schools money to help accomplish some of that. I think there's $160 billion. Again, this is all proposed legislation, so we don't know what it'll actually be or how that money will be distributed, but there's $160 billion in the proposal that's specifically to go to schools to help hire additional staff if you're trying to decrease class size and spread kids out more, to make improvements to school facilities, to buy those HEPA air filters if that's part of the standard. So again, a lot of details yet to be worked out, and I share, you know, your concerns, because I mean, it's great that all this stuff is coming, but it would have been great to have all this stuff, I don't know, 6-8 months ago. But you know, the obviously they couldn't get started back then, at least not the Biden team. So you know, they're doing the best they can, I think, and we'll just have to see what they come out with.
Well, we also know that the legislation includes some proposals relating to hazard pay. So how would that affect schools? Are educators going to be considered the types of essential workers for whom hazard pay is required under the proposals?
Yeah, so that's a great question, and I wish I knew the answer. So that the hazard pay proposal, if the other proposals are vague, this is a complete black box. You know, there have been some throwaway lines about calling on employers to provide hazard pay to certain frontline workers, but there's been very little clarity on what that means. I have not seen anything suggesting that there's going to be any mandate to any employers requiring them to pay hazard pay. What I have seen is really talking more about the, you know, workers in your grocery store who have to be there stocking shelves, or in the Amazon warehouse, or in the meat processing plant. Those essential workers who have been working in person. There's calls to pressure industry to provide hazard pay to those employees and to do it retroactively to the start of the pandemic. You know, I think it's somewhat unlikely that they're going to be looking at public schools in that same mode, in large part because public schools, many of them have been, you know, partially or fully remote for a good part of the pandemic. And so educators, in large part, haven't been put in the same position as those workers who haven't had a choice about showing up to work in person. But even those educators who have had to work in person during the course of the pandemic, you know, I haven't seen anything about a pressure campaign to make public sector employers provide back hazard pay to any of those workers. Now, with those calls to private industry, you can bet that there may be calls from unions to do some of that, especially for those workers who have been working in person. So that's something we can expect, but how strong any of that will be, or, you know, I don't know where the money is going to come from for that. So, you know, I don't know that this proposal is going to have a huge impact on the public schools.
And Bill, isn't the fact that, I mean, isn't the research coming out about rates of transmission in schools, isn't that going to impact somewhat, even if a union does make an argument? I mean, we're talking about, and you know, I've had these issues. We're talking about, you know, OSHA standards that apply to labs. Sometimes these unions are saying that apply to hospitals, and you know, they're just because, you know, I will say from personal experience that sometimes junior high boys are their hygiene is not great. That does not equate being within 6 feet of them to be in a, you know, in a plant that is with raw meat, or in a lab facility, or in a factory that's dealing with hazardous materials. And I see a lot of, you know, trying to use these. And for those of us who are not as experienced in OSHA, like we do have to go, you know, I think a lot of school administrators do, well, maybe that is, and you look and then you see, you know, what it really is supposed to be applied towards. And we're just not there in schools.
Yeah, I think that's right.
You mentioned retroactivity for the hazard pay idea. Is there anything else in the proposal that you've seen that is suggested to be retroactive? We had a question about that from one of our registrants.
You know, again, it's hard to say. I would be surprised if there was anything that was going to have a major retroactive effect. You know, for example, the leave provisions, there were some questions about whether that would apply retroactively. Obviously, if, you know, time is what it is and it only goes one direction, right? So you can't go back and grant leave to somebody who didn't take leave already retroactively. You could, in theory, I suppose, have a requirement that you provide retroactive pay for people who were taking unpaid leave during a period of time. It's possible that could be included. I haven't heard anything about it. I think it's somewhat unlikely because it doesn't really serve the public purpose of affording people time off going forward. You know, they already had the time off, and it just costs money for employers that may not have a lot of it to go around. So I think it's somewhat unlikely, but you know, again, we don't know until something actually makes it through Congress and is signed by the president.
So before we go on to our next topic, there were a couple questions in the Q&A that I thought maybe we could take a quick look at. And I know I'll give the warning that I know Bill gave earlier that, you know, as of right now, we're dealing with proposal. So I know we may not know the specific answers to specific questions. But one of the questions that we received was under the expansion, will the leave be full pay instead of 2/3 for emergency FMLA? Dana, you have thoughts on that?
I think you sort of answered the question before we even asked it, that we just don't know. As Bill indicated, we haven't actually seen the text of the legislation. This is just what has been previewed as part of Biden's plan. And, you know, I think going back when that provision was in there for people that did use it, you did see some school districts allowing people to use part sick leave or to do something, and made individual grants based on negotiations with unions, but we don't know that at this point.
Yeah, I think I have read reports that there are proposals to expand it to full pay and possibly increase the salary cap that was put in place under the old legislation. But yeah, like Dana said, we don't know what's going to make it through, and it's whatever is proposed, you have to assume that it's going to be negotiated back to some degree. So we don't know right now.
Okay, and then the other question, which again, maybe the same answer, would summer seasonal employees be subject to the $15 minimum wage?
On that, I can give a fairly confident answer that if the minimum wage is increased to $15 an hour, yes, it will apply to your summer seasonal employees.
Well, there we
but
go.
That remains a big if.
Okay, so that's great. But we can end our discussion about this proposed legislation on a concrete note. I love that. All right, so let's switch gears a little bit and talk about what happened yesterday in the Biden administration. It's the first half day of work, and yet we saw a number of executive actions that were taken yesterday. So would be interested to hear from you all if any of those executive orders have impact on school districts or employees. What should people here be looking at?
Maybe we can do a little potpourri here. One that jumped out to me, and Jackie, you do a lot of this training, is they ended the Trump ban on anti-bias training. So for that non-discrimination training, I don't know that a lot of people heeded that ban, to be honest. It hasn't been in place very long, and I think there's probably minimal risk of any consequences, especially for, but regardless, that's gone. So that would be one. I don't know if you guys want to jump in with some others.
Well, I can, to name one, there was an executive order signed yesterday that is designed at combating sexual orientation and gender identity discrimination. And specifically references Title VII, but basically it directs all federal agencies that have any authority over laws that prohibit sex or gender discrimination. So that would include, for example, Title VII, Title IX. It directs the agencies to construe those laws in a way that includes sexual orientation and gender identity within the broader rubric of sex and gender discrimination. That's consistent, by the way, with how the Supreme Court recently interpreted Title VII and construed it to apply to sexual orientation discrimination. So this is not, groundbreaking new law, but it does reflect the new administration's priority of actually enforcing the laws the Supreme Court has now, said that it should be construed, and something that we did not see under the Trump administration. So we can expect the EEOC, for example, to devote more resources to enforcing Title VII when it comes to sexual orientation and gender identity claims than might have been in the case in the past.
And for anyone who's interested in talking more, thinking more about some of these equity changes that we are seeing and that we probably will continue to see, we will be discussing that at our Title IX team meetup webinar, which is on February 2nd.
Yeah, I think that those are groundbreaking changes. And I also think that some of the funding, there might be funding implications and implications on some issues that are very important to some of your school communities. I mean, Biden did revoke the Trump policy of excluding non-citizens from being counted in the census. And as everyone has heard repeatedly, the census does drive federal grant money and other funding from the federal government. So that will be critical. And then for many of our school district clients, kids, families that have, undocumented status, this is a big population of people that you're trying to serve. And there's, immigration reform is top on Biden's agenda, and he is going to reinstitute the path that Obama started taking in offering citizenship to for undocumented immigrants and immediate green cards for those people that came in under the DREAM Act from the past. So these are things that I think are important, especially in school districts that serve populations where this impacts their daily lives. Important to keep up on that.
Okay, so can we pivot a little bit now and let's talk about a new decision on teacher dismissal that Dana, you were one of the authors for. We just put out an alert on this case. Can you tell us about what we should know?
Sure. So this is a little bit inside baseball. It's a little bit technical, especially, and it's really direct, but it's a great case, I think. It is the second appellate district in Illinois. And anyone that's done union or discipline of teachers or discipline of unionized employees, that just the progressive discipline path, somebody loses their mind and swears at a kid and you discipline them for that. And then, a year later, they decide they're going to come to work late 10 times in a row and not give you notice that the fact they're late. And you've got a class of 30 kids, sitting there twiddling their thumbs, or I guess in today's world on Zoom, waiting for some teacher to pop in. And, the union would say, well, you can't use that swearing episode to discipline for this, and especially in the notice to remedy context. There was like a case that was suggesting that like if you discipline someone and you give them a notice to remedy for a particular instance of misconduct, that you can't then fire them for a different instance of misconduct. And so this case sort of stands for the opposite of that. And it's the facts are interesting in that the teacher was accused of abusing her own children and a DCFS investigation began. And because it was, she's with kids at school, the district had to investigate that and find out what was going on. They did do that. They met with her several times. Then what happened was DCFS closed the case. They found it unfounded. So there was no indication of abuse. However, DCFS issued a report. The district received that report. And in reviewing that report, they found out that the teacher had lied to them. And so the teacher was issued that. We absolutely can't have that. That is not a safe situation to have teacher lie about a matter of student well-being. So she was instituted a notice to remedy. Fast forward a few years, she was a teacher that was working with a special ed teacher in a co-taught situation. So there was 2 teachers in the classroom. And she, on several occasions, just sort of blew off her responsibilities to be in the classroom. She, on one occasion, went to check flight status with United and ended up on the phone with the agent for 40 minutes out of a class period. And for those of us who are familiar with junior high class periods, that's pretty much the whole darn time. She went out to, I think, have a cigarette at one point, which is just priceless. That gives you a visual. You're supposed to be teaching and you're out in the parking lot having a cigarette. And so they said, that's it. We're firing you. When we gave you the first notice to remedy, even though it was for lying, we told you to maintain professional standards of behavior and meet your duties in a professional way. And so the teacher argued, well, that was for lying. I didn't lie this time. This shouldn't affect me, but the court disagreed. And actually, the circuit court actually agreed with the teacher, but the appellate court then came in and said, no, board, you were very clear that the teacher was supposed to maintain professional conduct in her duties. She did not do so when you have evidence that she left for these reasons that are not approved, and you can dismiss the teacher. So, this really stresses the importance of crafting the notice to remedy in a way that not only attacks the little instance of misconduct, the specific behavior, but also speaks more broadly to what the expectations are. And I think this is sort of like a breath of fresh air, because I think we get exhausted from having to tell people, you can't go out and have a cigarette while you're supposed to be teaching about like gerunds and participles or the prepositions or the periodic table. Not the time for a smoke break. So that's in a nutshell.
That's great. That's a powerful decision and one that, really recognizes the reality of the classroom in a great way. All right, so switching gears a little bit more. So with COVID and remote learning, the days of the snow day are basically gone. And so with students working on snow days and every other day through remote learning, we've heard some discussion about extension of the school year to use emergency days as additional instructional days. So what do we think about that?
So there are issues, to say the least. There's definitely going to be some labor issues. You can't just convert those to instructional days without conflicting with your obligations to your union. There's also possibly statutory issues as far as whether it's even authorized. And especially in this podcast, we're not in the business of dissuading educators from getting creative during this time and trying to offer something they think their school needs. But this is one where I just throw up a caution sign and definitely speak to someone about this, because there are big time issues. You definitely wouldn't just want to wave the wand and turn them into days and think you might be okay. You probably wouldn't be.
Right. And I also think this is another example of something that maybe we wait and see, because part of this aid, I think, and part of what Biden's, packages and what he's trying to put forth might address somewhat funding and summer school and how we're going to run this, and sitting down. I mean, there's statutory provisions that govern the length of the school year, so there's that hurdle. There's the labor issue. So starting to navigate those issues right now, you might be better off waiting a little bit so we can see what develops in terms of what is the plan going to be, because I think this is really related to everyone's desire to have a plan to start to remediate this period of e-learning. And while there's been some things we've learned, and it's not like nothing has happened, I think it's universally acknowledged now that this has not been the same for many, many children, especially younger children and children with special needs. And we are going to have to look for time and ways to build more programming for these students to close the gap that this pandemic has created for them.
Yeah, I think we'll probably talk more about this next week when we're more focused on IEP issues, but I am getting, and I'm hearing an increasing anxiousness from parents who are saying, what are you going to do? And they throw out, the term compensatory services. How are you going to make up the time? It's thrown out in some different ways. We don't want to file a due process against you, but this has really been bad. What are you going to do, school district? And I guess being the skeptic that I am, I mean, some of those, I guess I wouldn't want to be too scattered in my approach. I'm still trying to we only know so much and can plan so much right now. We don't know when, we don't even know when children will be vaccinated. We don't know when our own staffs will be vaccinated. We don't know that summer will be better than it is now, for sure. We hope that it is. So there's so many unknowns. And I guess I get a little bit nervous. My experience with some of these parents is we can say, okay, let's add 2 more weeks to ESY, but that might do almost nothing to mitigate. If your goal is to avoid liability in comp ed, you got to kind of think what your goal is. Is it really we're going to look at our population and holistically address where we think the gaps are? Or are we trying to just appease some parents so they don't sue us? Those are 2 different things, So I guess I would just think about that as you're looking to summer and looking for some of these maybe post-COVID remediations. Think about what your goals are, and if the goal is just to get parents to not sue you, and it's one specific family, then we need to be more precise, because they can still sue you even if you think you're doing what they want. Anyways, I'm kind of rambling about this, but it really is an increasing issue, and delay because we don't have good answers yet. And I think that's the best strategy for now. Be thinking about it, but don't think you're going to solve it with a plan right now.
Okay, so switching gears a little bit again, Jennifer, another major development here in Illinois that we just put out an alert on. So if you do not receive our alerts, please make sure you go over to frantic.com and sign up, because you will find lots of good information coming to your inbox there. But Jennifer, for those who haven't had a chance to look at that, can you tell us about the passage of the Black Caucus education bill? What is the status of the bill and what's in it?
Well, this is maybe another good example of all the moving pieces that are out there, because the Black Caucus education bill at one point did have an extension of the school year as part of the proposal, and that was removed. So that's another good example of, you might try, if it had not been removed and you were trying to do the snow day thing, there's just all these moving pieces still out there. But anyways, so what is in it? There are heightened graduation requirements, some new provisions on accelerated placement, the history curriculum. I looked in some detail at the graduation requirement language. It will be, assuming the governor signs it, so it's it's on the governor's desk basically right now. So if it were to be signed into law, it's phased in. So this is not a wave the wand and high school kids right now need to worry about this. It will be something that the curriculum will need to catch up with over the next several years. And it aligns, it heightens the foreign language, the science labs. There's just some increased, I guess, rigor in a way to the graduation requirements. I did notice it's very explicit in there that those requirements would be waived, could be waived by an IEP team. So it might be another reason, you know, for those kids that one would be on the fence. Sometimes there's different reasons why a parent might seek an IEP. And now, you know, it's very clear that some of these more rigorous graduation requirements could be waived by an IEP team. That might be something teams deal with more as we go. Right now, you know, it seems like most IEP teams can find classes for a kid that is graduation bound, but some of the description makes the classes seem rather rigorous that they must take.
We've had a lot of questions recently about the vaccine, and specifically about what happens if a school district or school is in a position where they are using their facilities as vaccination sites, or even signing up to give out vaccinations themselves. Can we talk a little bit about potential liability? What do schools need to be thinking about as they're making these choices?
Had to happen at least once. I was on mute and there it happened. So now it's over. It's like the elephant in the room. So I think this is a big issue for school districts right now, because some of them are being approached already as potential vaccination sites. And I think that for some people, that's, you know, some administrators, that's like, bring it on. We can't wait to use our building as this vaccination site. And others, I think it causes some worry and consternation about not only liability issues, but just logistics. If we're bringing kids back, how are we also going to have people coming? I mean, just like voting, that caused consternation, and it ended up being election day being a day off of school, because just accommodating all those extra people that are coming to school while you're having school is an issue. So there are some provisions that have been passed to sort of shield the school district from some of the liability that might be associated with being a test site. And I think you need to, if you are considering this is something that you need to start consulting with legal counsel about, and looking at intergovernmental agreements, other types of use agreements. Actually, that's not what I meant. I meant a use agreement for your facility, in terms of how this will happen. And that can shield you from some of the issues.
And yeah, we've had a number of people reach out. We definitely have, if you have questions about what liability might look like, what you should be thinking about, I do think we're going to be putting out an alert soon on it. But, you know, generally speaking, there are some protections out there for you with the PrEP Act specifically. But please do make sure that you call on your contract attorneys like Brian Crowley from our office if you're looking for assistance on putting some things in place that can give you that added boost of protection. All right, Jennifer, we wanted to know about if there have been any changes in the demands that have been placed on educators in divorce or child custody disputes.
Well, I don't have any data. This is something that I've observed recently, is that we're getting a flood of subpoenas, requests for records, guardian ad litem investigations. And I think it's just a sad effect of COVID in a number of ways. I mean, some of these proceedings were delayed at the front end of COVID when courts were initially shut down. And I think courts are more up to speed at this point and getting through their docket. So some of it may just be a rush due not to increase filings, but just because some filings were on hold. Sadly, I think some of it is due to, I mean, I don't know, but it feels like an increase in divorce filings and custody disputes. And certainly schools through remote learning are one of the only sort of peek into households where some parents are making allegations of abuse or poor parenting, reasons for custody to change. So they are trying to get their hands, so to speak, the judicial system, whether it's the attorneys, the guardians ad litem, on teachers to try to find out more about what's going on in homes and what is in the best interest of children as far as custody. I would say this is really a problem in a couple, I mean, so the goals are good ones. Obviously, it's the system to protect and figure out who a child should live with. But the challenge becomes, so sometimes it's, you know, one parent accusing the other parent of being a bad parent. Well, when the teacher puts the thumb on the scale and, you know, but then the bad parent doesn't lose rights, it really does cause a breach in that trust between the parent and the teacher. And that, especially right now, when there has to be so much collaboration between teachers and parents, if there's remote learning periods, I mean, always there has to be collaboration. But that's why I really handle those matters. I try to really protect and insulate the teacher as much as possible from those disputes. So I would really hesitate, you know, your staff is often, they want to just be helpful. And so they might get an email from a parent and say, I'm going through this divorce. Can you say something about how I'm a better parent? You know, you've observed that my ex is a deadbeat loser, and it would really help if you could let the court know that. You know, some teachers want to be helpful. That's red flags all over the place. So definitely, this is something, whether it's your administrators could certainly do it, or if there's attorneys involved, this is a role that we've been playing a lot, is just put the brakes on those, try to get the information that they need to make the legal process go forward without harming that teacher-parent relationship.
Yeah, I mean, I think there's a huge difference between, I mean, if you are teaching this is where teachers really need guidance from administrators and refreshers. I mean, I know we're all running around crazy trying to make our new reality work, but teachers, teachers were always alone with kids, right? But now when they're doing Zoom, they're also alone with parents. In situations where typically it would be through a conference, there would be an administrator bopping around. You would know if it was a difficult parent, you would have another teacher, maybe team with you and have that conference. But I've had situations where, you know, parents have come into the Zoom or later emailed a teacher, you know, my ex-husband does not have material, you know, doesn't have his Post-it notes as organized as I do. Please write a letter about how I'm a better parent because I run my home classroom much better than he runs his. You should not delve into that. That's distinct from if you see someone being harmed, you know, if you see you still have an obligation. But I think some parents are trying to say, get teachers into this battle, as Jennifer said, and that's just gonna blow up later. It's not a good. Then there's no one that's neutral for the student either. So, I mean, I also encourage school districts to, if there is a guardian ad litem, reach out to that person. Sometimes they can be hard to track, but you really need to make a connection with that person. That person can have influence and has rights to have records and things, and you should utilize that person.
Right, and just building off of what Jennifer said about trying to keep the relationship in place, even if you're saying no, that can be a really good role for an attorney to play, where if you receive a subpoena or a request, that the attorney can be the one to come in and say to the other attorneys for the parents, this is impossible, we need to find a way to, you know, not do this, instead of it having to be the teacher saying to the parent no. And then also just, you know, often people don't think that they need counsel for testifying, but I know, having done it myself a number of times, of meeting with and helping prepare a teacher or another school staff member to be able to, if they have to testify, to know how to deftly balance all of the things that we're talking about here. That's a place where, you know, we also, or other, your attorney, your board attorney can come in. Great help. So we did get a comment I wanted to share in the chat, which is from a school district that has explained that they are providing vaccines today in their gym to their staff, and use a remote planning day for today, and we'll use another on February 18th for the second dose, and that teachers get their shots and then attend to department meetings. And I'll tell you, as a parent of 2 elementary age children, that is music to my ears. Very excited to get our teachers vaccinated and get everyone safely back to school.
Yeah,
So
that's very positive.
We don't have any additional questions, so we will go ahead and sign off for today. Thank you all so much for sending in your questions beforehand, for submitting them through the Q&A. As always, if there are things that you would like us to answer in one of our COVID webinars, please do send an email to covid@fransic.com, and we do very much rely on those when we're preparing these discussions. And then also, again, make sure that you let your teams know about our exciting session next week, where we're going to be talking about IEPs in the time of COVID. So please mark your calendar for that and make sure you get everyone registered. All right. Thank you all, as always, for joining us. And until next time, take care. Bye, everyone.